Welcome, everyone, to another episode of Inside R&E. I'm your host today, Justin Weitzman. I'm counsel in the Litigation Department here at Rosenberg and Estes, and I specialize in real estate as well as commercial litigation with the firm. My guest today, I have the privilege of introducing a friend and a fellow attorney in the field, Chris Seleski, who's a personal injury attorney with Tolmage, Peskin, Harris, and Falick. And the reason why I asked Chris to come on here today is that Rosenberg and Estes represents a lot of property owners, whether it's landlords, developers, or just simply homeowners. And unfortunately, the cost of doing business with property ownership is the risk and exposure to potential personal injury claims on the property that our clients own. Whether it be a trip and fall on snow or ice on the sidewalk outside of the property, or even injuries to workers performing construction in the property. So Chris is here to give a little perspective from the other side as someone who prosecutes these claims on behalf of injured parties against property owners, so in order to give some of the Rosenberg and Estes clients a little perspective on how they can possibly safeguard against these types of claims. Chris, welcome to the Inside R&E podcast. Please introduce yourself and give all your credentials, which I know you have many of.
Well, thank you, Justin. I'm really pleased to be here today with you on the R&E podcast. Generally people look at, from the property owner, landlord side, I'm the people that I'm the type of person that you don't want to meet, because that means somebody got injured in your property. But I think the main thing that personal injury attorneys are really concerned about is safety and preventing these accidents from happening. And I've been doing this for about 13 years with my firm, Tolmage, Peskin, Harris, and Falick. And, I'm really excited today to share some of the things that I've seen from the front lines to guide people to, seek more questions and to make sure their properties are safe and to protect themselves from liability if something does go wrong.
Now, Chris, I understand that your practice encompasses personal injury claims across the spectrum, whether it can be, asbestos litigation, dog bite injuries, you name it. But what are some of the most common personal injury claims that you see involved in, at least for our clients, real estate ownership and property type personal injury claims?
So generally the biggest thing that we see is trip and falls over defects on the sidewalk. But there's also ice and snow removal, slip and falls, unleveled mats in vestibules and doorways, elevator issues. The common one is misleveling elevators, which cause people to trip while they're going out. And then there's also gas line explosions, people who are injured on the job building, in construction accidents. Those are the main things that we see.
Now, when it comes to, personal injury claims as it relates to property ownership, it generally falls into the category of what they call premises liability law, right? You own a
Correct.
premises, you have liability by owning a premises if it's not in a certain condition and someone gets injured. How does premises liability law work or apply as to landlords versus property managers or anybody else affiliated with a property?
Yeah, so it sometimes depends on the type of accident that occurs on the property. When it comes to most of them, if not all of them, the owner of the building's always going to be on the hook in some way for an accident. And same with the landlord, superintendent, and oftentimes as well, tenants of the building itself, commercial tenants, are the bulk of who is affected. There's, when it comes to, for instance, the Sidewalk Law, owner-occupied residential houses for one family, two family, or three family are excluded from the Sidewalk Law. That's it's delegated to the city to maintain those sidewalks. But everything else, every public sidewalk in New York City, if it's not owned by the city or a one family, two family, or three family home, the building owner will be the responsible party.
So what we happen to see here a lot, when we're litigating these types of claims, is that for our clients, commercial landlords will transfer the liability through an indemnification in a commercial lease, whereas the commercial tenant will take on the liability for a personal injury claim that happens on their premises. But at the end of the day, the landlord owner is still always responsible. So that indemnification is only as good as the tenant that's giving it to you, right? So a lot of times you need to make sure that you have somebody on the other end of that indemnification that's going to be ready to and able to stand up and defend the claims. But it brings me to my next point. Like, I don't want you to give away the secrets and put yourself out of business here, but I guess what are some of the things as a personal injury attorney that you see that would be, steps or recommendations for a developer or landlord to take in order to help prevent or limit exposure for personal injury claims on their properties?
Sure. So first, I just want to say that this isn't, none of this today is going to be legal advice. It's just information that I'm giving out, and I hope it leads to more questions where, people who listen and have questions will reach out to an attorney to get specifics, and because every case is and every property is different in the city. So this is all just, generally speaking, general information for the public. The property owners, when they do delegate that, say keeping the sidewalk free and clear of any defects, of any debris, of snow and ice removal, even if they do delegate that duty over to the tenant of the property, well, then the owner thinks, oh, they're free and clear, they're off the hook, right? Now, under the law, it's called a non-delegable duty, which means you can't delegate it out to somebody else. You're still on the hook. So property owners have to know that they also have to keep tabs of their sidewalks and their elevators and their staircases and the lighting conditions, in order to protect themselves from liability, and ideally, to keep the property safe in itself, so accidents don't happen. Or if they do, you'll have documented evidence that you did everything you could do at that time.
So obviously, we touched on it a little bit before, that premises liability is not the only risk or exposure to property owners as far as personal injury matters are concerned, but there's also the construction aspect of it, right? Whether somebody is a developer doing ground up construction, or even day to day, if you have workers in your building making a repair, or vendors coming from the outside to even perform daily, monthly maintenance on a certain aspect of your building, these workers are also covered by, different laws. There's New York labor laws, which cover, people actually working from elevated heights and situations like that. Could you, go into a little bit about, the potential risks and liability exposure for workers, construction going on in a property?
Sure. So under New York law, it's called Labor Law 240 and Labor Law 241. They have essentially strict liability when it comes to falls from heights, whether it's a person falling from a height, or it's a hammer falling from a height. Essentially, if the safety equipment was not provided to the workers, the owner's going to be on the hook for on those damages. Not just the owner; it could be a contractor, a subcontractor, whoever's in charge of that kind of situation, operation, and who has control over that work site. They could be held liable, and obviously, fall from heights are oftentimes very tragic cases. And a lot of wrongful death cases, come from that as well. So another thing that people should know on the podcast, and I hope this spurs you to do it, is the name of the game in all of these cases with premises liability is your insurance coverage. You got to make sure you're covered for these sorts of things, such as having, workers' comp insurance, having umbrella policies. I'm not an insurance salesman or agent, but I encourage everybody here to not only, contact your broker and see, what your policy actually covers in these situations, but also to make sure you have a broker who you're comfortable with and somebody who is going to sit down and explain it to you. It's, easy to go online and just pick the cheapest policy you can find out there, but for a few pennies more, you can get a better policy and really make sure you're covered in these situations if the worst happens.
Now, on the topic of insurance, I mean, anybody who's ever had insurance, whether it's, for their property or even their own insurance, always knows that insurance companies are always looking for a way to get out of paying claims or even defending claims. They usually do so under what's called a reservation of rights, or they'll say, we're even disclaiming, we're denying your claim. From your side, how do you deal with, or what do you see the biggest issues with when an insurance company denies a claim saying to a property owner, you didn't have the sufficient, required insurance for this type of claim?
Well, in that case, frankly, a personal injury attorney doesn't really care. We're still going to go after you and try to get, justice, or try to get compensation for somebody's injuries. And if you don't have the right coverage, your company could be on the hook. In some instances, you personally could be on the hook for it. So you really want to make sure you have that coverage in place. So that way, if you do get sued, all you have to do is take that letter or take those, the summons and complaint, forward it to your insurance company, and then they hire their attorneys. They do all that, work for you, and you don't have to, you can have some peace of mind that way, knowing that you're protected.
So from your end of the things, of the spectrum, have you ever, or is there a typical case that comes about where you've seen insurance companies routinely deny a claim to a property owner, and that it's like, I don't call it like a gap in insurance coverage, but it's something that maybe a lot of people are overlooking in getting, and then they could be hurting from it in the long run?
Yeah, I would say workers' compensation insurance is a big one in construction accidents. There's oftentimes, I guess I would say, or sometimes when people don't have that, they'll try to lie their way out of it and say that this person wasn't working from them, they were never on their work site, or something like that, and it ends up hurting everybody in the end when you go that way. Eventually, people are gonna, everything is recorded in New York City. Essentially, everything's on camera, everything's online. They're going to find out that this person worked for you. We're going to find out whether or not you had insurance. That's one of the first things, that we look at. And if it's, and if you're not covering your workers, your employees, that could be a big issue for you in the long run. And it really, it hurts your workers, and it can hurt your business overall as well.
Now, it's always great to try to give examples to people. A lot of our property owner clients might be sitting here and say, I've never had an issue with a personal injury matter. So can you share a case where like a developer or a landlord property owner faced a significant personal injury claim? What was the outcome? What type of case was it?
Sure. I've got stories for days if you want. But I'll say that, any type of accident could end up being significant over time. Just a trip and fall, say on the sidewalk, could lead to massive liability. For instance, somebody with diabetes, when they trip and fall, there's a lot of issues with their blood and clotting and things like that. A lot of times, if somebody with diabetes gets injured, they're going to end up being an amputee. When that happens, it's generally 7-figure case, or a high 6-figure case. You have stairs are another really big one. And stairs and elevators are also very, very important. If there's ever any code violations, that's a red flag. You got to take care of those kinds of things, as soon as practically possible. A trip and fall on a stairway, if someone's going down and they fall down multiple stairs, you're talking head injuries or even death. in those situations. A trip and fall on the sidewalk can lead to death as well. People have, hit their heads, or things like that happen. And I'll tell you, in my profession, like, if you can dream it, it's probably happened. We always say, like, you can't make this stuff up. But it's wild, some of the ways accidents happen. And just by taking a few steps and a few measures to inspect your buildings, to inspect your sidewalks, inspect your stairs, elevators, gas lines, things like that, can really go a long way in preventing these things from happening.
Yeah, I mean, you talk about sidewalks. I think we live in New York City. There's a lot of foot traffic, and I think one of the most, given that we're in New York City and the weather conditions we have here, one of the most prevalent types of premises liability cases are when it snows or it's icy out. You always see people out there in advance of any potential snowstorm or freezing conditions with salt. I presume that's just a measure to safeguard against a potentially very, very common type of personal injury claim.
Yeah, absolutely. The snow removal law is kind of complex in New York, believe it or not, when it comes to sidewalks. You have 4 hours essentially after it stops snowing to clear the snow from the sidewalk, so it's safe for people to walk on. If the snow stops overnight between 9 p.m. and 7 p.m., then you have by 11 a.m. the next morning to have it free and clear of those conditions. But there's all sorts of things that, if you have a leaky pipe and it's water's running out, that's going to freeze. That's going to cause black ice. Those sorts of things should be, on the front of the porters of your buildings, the superintendent of your buildings, to be on the lookout for, because if they see something like that, it should get, fixed as soon as possible. And if there's ice, you have to put up, cones, maybe block that section of the sidewalk off. But a lot of people, you look at a sidewalk and you see, a gap between the sidewalk flags, or you see, a defect, a raised or lowered section of the sidewalk. And you think, oh, no one's going to really trip over that. It's kind of small. It doesn't matter. But, a public sidewalk has to be free and clear for the public to work on, to walk on. That includes children. That includes people with disabilities. That includes, the old and infirmed. It applies to everybody. And New York has a kind of a standard, I'd say, when it comes to those types of things as well. And we call it the Sidewalk Law. It's New York Administrative Code 7-210, where essentially, if you have anything that's a defect of height, a misleveling of something, if it's a half inch or higher, that's considered essentially a defect. I've been in depositions with superintendents in the past who said, well, yeah, it was only a half inch, so we don't repair those sorts of things. If it was 7 or 8 inches, that's half a foot. That's a huge defect. Of course you want to repair that. But even those ones that you might not consider being defective, half inch is kind of the gold standard in New York City.
When you're litigating a personal injury claim, what do you find is some of the biggest pitfalls that developers or owners or landlords make that would be able to put them in a better position in court? Or is it not having procedures or policies in place or documentation? What are like simple things that obviously accidents happen, but what are simple things that can put them in a better position in court for defending these types of claims?
So I think what you touched on is absolutely right. You have to, documentation is key. And you said also that procedures that you have in place is also key. But I think also along with that is consistency. To have that consistent follow-up with your staff, with your landlord, with your super, whoever that may be, to make sure they're consistently doing these things and consistently documenting those things. If if a stranger comes up to the sidewalk on your premises and just starts jackhammering away and creates a big hole, and somebody falls in that hole 5 minutes later, you're going to be free and clear of that because it was obviously this other person's fault. You had no notice of it. And that's what it comes down to is actual notice that you or someone on your staff walked by this defect every day. You saw it, you were aware of it, and you did nothing. Or constructive notice that it's been there for so long that you should have known that it was there and should have fixed it. Now, with technology nowadays, it's a lot easier to prove notice. You have surveillance cameras oftentimes where you may be able to see and go back and see that defect. But I'll tell you, one of the first things that I do when I get a trip and fall case is I go on Google Maps. On Google Maps, you can go back in time on Street View. So I can go back, 3 years, 5 years, 10 years sometimes on a property. And if I can see that same defect that my client, tripped over, that was there 5 years ago, I know I'm off and running with something because it was obviously there. It's obviously that defect, and Google Maps just essentially sold that property owner out,
Now you have to call Google to come in and testify for you, right?
Well, they changed the law a few years ago. It's self-authenticating now,
okay.
Google Maps. So you can just show that to the court and it's acceptable evidence. Back in the day, you'd need somebody from Google to testify that this was a clear and accurate representation that it was at the time. But the courts made it easier and said, yeah, it's Google Maps. We all take it as the real deal. It's not like a photograph that some photographer took that nobody knows. This is Google. They have their technology in place, and the court trusts it.
So you mentioned something about technology as technology evolves, its interplay with personal injury lawsuits. As you said, surveillance footage is becoming more prevalent. Is there any other emerging trends in personal injury cases related to property ownership?
Sure. I mean, the biggest one I would say is cameras and surveillance video. To make sure a lot of people have that in place now. The cost of installing it is not, as outrageous as it used to be. Also, digital maintenance logs are also a big thing to help stay compliant with local laws. You have different softwares that are out there. I've had a few of them through discovery. I'm sure there's a lot out there, and I don't have a recommendation on which type of digital maintenance system to use. But once you have that in place, it's super easy to have people on their phones. They can take pictures of anything that they think needs to be fixed. They can put in work orders. They can show that they've are actively fixing their property, actively fixing any defects that property owners see.
So, I've had clients in the past, more in recent actually, now talking about situations with e-scooters and bikes as it relates to property owners' liability, whether it's on the sidewalk or even now we're seeing, e-bikes potentially having explosive parts in buildings. I think there was a case on that. Have you dealt with these situations? Is this something that's emerging?
It's something that it's emerging, and it's kind of a new topic here in New York City. I don't think the laws really sorted things out in this because, there's certain types of bikes, depending on how fast that particular e-bike or scooter can go, that aren't allowed on the sidewalks. So by, being on the sidewalk in the first place and running over somebody in front of your property, that's generally going to be that person on the scooter's fault and not yours. But it's the same thing when it comes to people walking on your sidewalk. If you have a sidewalk, and somebody's on their e-scooter coming in to park on the sidewalk, and there's a defect and it causes injury, well, you could still be on the hook for that defect. There's the law is still not completely clear on, and it depends. It's kind of a case by case thing. So the courts are still kind of sorting that out when it comes to e-bikes, but essentially I'd say you're still on the hook if a bicycle or e-bike scooter um, fell over because of something defective on your property.
Now, what we've seen more and more happening in New York is that there are more and more local laws being established to, typically unfortunately they happen after an accident occurs, but you have local law 11, which has been around for a long time for facade repairs. You've got local law 126 for the garage inspections, 152 for gas inspections. Is this something that as a personal injury attorney, you also monitor like we do? Because like you said before, one of the easiest things to, I wouldn't say win on a case is, or to help establish liability in cases, if there's code violations or building violations on a property that is the condition that is alleged to cause the injury. It helps build your case. So, I mean, these types of things that you as a personal injury attorney pay attention to, and also, see as compliance with for on behalf of property owners is a key to helping limiting liability.
Absolutely. One of the first things besides checking out that property on Google Maps and going back in time through the street view is looking up code violations for that building. There's times where even if they have 10 different code violations, none of them may even apply to your case, but that tells you something there about what how much the property owner is really trying to pay attention to to fix whatever is hazardous on their property and to make the property safe. So you have local law 11, for instance, which came into existence, I believe, around 1998. A bunch of bricks from buildings were cracked and falling out, and then they would, fall from many stories up and fall and kill people. And so rightfully so, I think the city said, we're going to put in this and start enforcing this local law 11 to have, any building that's 6 stories or higher get inspected every 5 years, and you have to file a report to do that with the Department of Buildings. Same with local law 152, which I listened to your podcast on the R&E regarding 152, and it's very informative on that subject. Anything that's a code, if somebody trips and falls, on a defective staircase, or say they started to fall, they grabbed onto the railing and the railing fell out of the wall and they went tumbling down the stairs. Well, if there's a second stairway on that property, and that stairway, there was code violations found, or many complaints from tenants, let's say, about that other staircase, there's still an argument to be made that if you had to fix one staircase, you should probably have checked all of your other staircases. If you found a defect on your sidewalk, you should walk around the rest of your sidewalk to make sure everything else is safe too. And I think that kills 2 birds with 1 stone, or hatches 2 birds with 1 egg, however you want to say it, is that if you're having somebody out there to repair your sidewalk at this one spot anyways, you might as well have them repair the other spots that are down the road. You see a lot of patchwork done in buildings around the city, and I think that just gets people into more property owners, most so, property owners on the hook for things that really, really could have and should have been prevented if they just would have gone maybe one step further to fix, another issue that could have been found at that same time.
So you might have just said it in their, thing, but what is, I guess, the number one piece of advice? Again, not legal advice, but the number one piece of advice you give to real estate professionals and owners to avoid costly lawsuits and potential liability?
Documentation is the name of the game. Have systems in place where you can show and you can prove that you were diligent, and that any any defect in the past that you've had, whether it's a complaint from the city of New York, whether it's a complaint from a tenant, that you looked into it and it got fixed. Not only that, and having those records, take photos. It's, I can't tell you how many times we get all these records and say that, oh, this window was fixed, but then the next tenant who moved in after that window was fixed, fell out of its siding and collapsed and, shattered someone's hand, for instance. I had a case like that. If they had photographs, if you have video of, a working window and say, it's one of those things like the guy with the jackhammer on your property where, a window, because it gets cold or because it gets hot, it expands or collapses. Maybe you have a defense there. But also you want to make sure that the work you have done is done correctly. And then once that, work is done correctly, document it. Don't just do it and think you're safe. Document it, because you never know what will happen after that.
Yeah, I don't know how many people, listening to the podcast or know this about me, but I used to be in insurance defense. So I can certainly attest to the fact that surveillance video and having proper documentation in place. I had one case, I'm sure people have heard the same story before. I had one case where an individual was claiming to have been injured while she was working on the job. And then we looked at surveillance video and at the time and location of the accident, and the surveillance showed that no accident even occurred. So, after that, the case was over pretty quick. But, I have my stories, I think, Chris, a lot of times our listeners and people want to hear, what is one of the more interesting cases you've had with as it dealt with like a property owner? Like, what were the facts and what was the potential exposure at the end of the day to the property owner? Give us a war story.
Sure. We had a case where it was a very, very nice building that a journalist worked in, or I'm sorry, that a journalist lived in, and she's going out to walk her dog in the morning. She takes the elevator down, and the elevator goes down about 1.5 inches lower than it should have. And she's walking out of the elevator with her little dog on a leash, ready to go walk her dog first thing in the morning. Expects the elevator to be level, but it's not, and ends up tripping and falling and fracturing her skull, fracturing her wrist. Very, very, severe injuries that happened. The issues kind of there is, we had there were cameras in the lobby, so we had video evidence of the accident, actually occurring. But then we got the co-op board records, and we saw that there had been several complaints about this elevator misleveling. We saw repair records from, elevator companies coming in and trying to fix it. But obviously, they didn't fix it because it's on camera there. And that the, elevator misaligned. So you want to, and that case, settled for high 6 figures, 7 figures, in that instance. So, something that's just, 1.5 inches and 1/2 inch even, on an elevator misleveling could cost, potentially 7 figures, in that sort of, accident. And then, you have lots of, other cases where, you look at, a trip and fall on the sidewalk, and you go onto Google Maps and you see that exact same crack that you have photos of, or that your client took photos of after the accident, is right there 5 years ago and nothing happened. And those kinds of cases, if you're a property owner, go on Google Maps, look back in time. Are there defects there? Are they still there, on your sidewalks? That's something that should be looked at right away, because if someone's on the street with their Google Map camera and they can see it from all the way over there, it's probably substantial, or at least in the eyes of the law. And, it's something that needs to be fixed. So the next time that Google car, goes down the street, it'll prove that defect's no longer there.
No, who would have thought that the Google cart would be like a key player in personal injury litigation
Right.
when it first came out? No, Chris, we'll wrap up the podcast here, but I just want you to get out your information to our listeners, how they can reach you, what types of cases can you handle, and what's the best way to contact you.
Sure. So my firm handles, general personal injury claims. So from trip and fall, car accidents. We also do medical malpractice, construction accidents, and essentially, if you've been severely injured, you should be contacting an attorney, and all consultations are free. But if you have questions too of premises liability questions, you're always free to reach out to me. You can call 212-964-1390 to reach me at the law offices of Tolmage, Peskin, Harrison, Falick. And always happy to serve as a resource for people.
Well, thanks so much, Chris. I really appreciate you jumping on here. I'm sure that our landlord, developer, property owner clients are going to get a lot of information that they haven't heard anywhere else before, or have only heard after they've been exposed to one of these cases, which is always the problem, is you need to hear it beforehand.
Exactly.
Again, I'm Justin Weitzman. I'm counsel in the litigation department here at Rosenberg and Estes, specializing in real estate litigation as well as commercial litigation. I can be reached at 212-551-1261, or my email address is jweitzman@rosenbergestes.com. Chris, thank you so much for being on Inside R&E.
Thank you, Justin. Property managers, landowners, document, follow through, and call your insurance broker and make sure that you're covered. Thanks for having me, Justin.